Good morning. As you're logging in, we're just going to leave it for a couple of minutes and just allow everybody time to get logged in. You're very welcome. So just bear with us if you will. You're all very welcome. We are going to make a start just in another moment. We're just allowing people to get logged in and then we will commence the webinar. Okay, good morning. You're all very, very welcome this morning. And after a summer break, this is the first in the next season of webinars kindly provided to us by our patrons, legal patrons, Mills Selig. Very important topic this morning. If, like me, you thought we'd stop talking about GDPR in 2018, no, it is still an important topic. It's something everybody probably dealt with and got their houses in order at that point in time, but it's something I think like a garden, it needs constant attention and it's very important. So actually very grateful to Mills Selig for raising this topic with us this morning. This morning we're going to have a few different speakers. We've got Glenn Watterson, a familiar face to us on the Mills Selig webinars, and Glenn's colleague Catherine O'Hagan. Catherine, you're very welcome. You're a solicitor also with Mills Selig, and we'll also be hearing from Chris Kelly, barrister from Briefed. Just remind you in normal fashion that these webinars are being recorded and they are being uploaded to the CEF YouTube channel. That's to allow you to go back and have a look over some of these important slides again or share it with colleagues. So just so that you do know that it is being recorded, and that is a reminder, we do have quite a library now of Mills Selig webinars available to you on a range of topics up there on the YouTube channel. We will have other events being added to our website very shortly. So with no more ado, I'll just ask you if you have questions through the morning, use the Q&A function and I will share questions at the end of the webinar. So please do make use of that Q&A function at the bottom of your screen. And I'll ask those questions on your behalf at the end. And I will now then pass over to Glenn. Good morning, Glenn.
Hi, Mark. Hi, everyone. Thanks for having us back this year after, I suppose it was a great year last year just on the webinars. Kicking off with the exciting topic of the data protection this year. Just a bit of background on Mills Selig for anyone who's not aware. We are local independent law firm specializing in all matters of business law, whether it be your property needs, employment, employees, construction, contracts. We can advise on all sort of requirements that the business needs. Today I'm joined by Catherine O'Hagan, who's going to lead on the webinar. Catherine's our specialist in GDPR and data protection matters, and a member of our corporate team. And Catherine will lead off on the Data Protection Act and all of the principles in data protection. And Chris is going to give us, I suppose, some more practical advice on what the business need to do to make sure they're sort of in compliance. So without further ado, I'll let Catherine kick off, and if anyone has any questions, as Mark said, we'll deal with those at the end. Thanks.
Hi all. So I'll just get straight into it. So all aspects of data protection are important, and as I'm sure you're all aware, the legislation surrounding processing individuals' information has become stricter and tighter in recent years. The penalties have a potential reputational damage and have been ever increasing. It is therefore important to be familiar with the relevant legislation and how to ensure you and your business are compliant with it. So in the UK, the main pieces of data protection legislation are the General Data Protection Regulation, also known as the EU GDPR, and this was brought into effect on the 25th of May 2018, and it is the toughest privacy and security law in the world. Though it was drafted and passed by the European Union, it imposes obligations onto organisations anywhere, so long as they target or collect data related to people in the EU. Since the end of the Brexit transition period on the 31st of December 2020, the EU GDPR no longer applies to the processing of UK residents' personal data. However, it does still apply to UK organisations that process EU residents' personal data. We also then have the Data Protection Act 2018, also known as the UK DPA. This is a comprehensive modern data protection law for the UK, which also came into force on the 25th of May 2018, the same day as the EU GDPR. Post-Brexit, a retained version of the EU GDPR became part of the law of England and Wales, Scotland and Northern Ireland by virtue of Section 3 of the European Union Withdrawal Act 2018. This is known as the UK GDPR. The UK GDPR explains the general data protection regime that applies to most UK businesses and organisations. It covers the UK General Data Protection Regulation, tailored by the Data Protection Act 2018, and explains each of the data protection principles, rights, and obligations. The Privacy and Electronic Communications Regulations sit alongside the Data Protection Act and the UK GDPR. While GDPR only applies to the processing of personal data, these regulations regulate electronic communication, even if it concerns non-personal data. They give people specific privacy rights in relation to electronic communications, and there are specific rules on marketing calls, emails, texts, faxes, cookies, and any similar technologies, keeping communication services secure and customer privacy as regards to the traffic and location data, itemized billing, line identification, and directory listings. So the scope of the legislation, as I previously touched on, if you process personal data of EU citizens or residents, or if you offer goods or services to such people, then the EU GDPR applies to you, even if you're not in the EU. The UK GDPR applies to processing carried out by organisations operating within the UK, and also applies to organisations outside the UK that offer goods or services to individuals in the UK. The penalties and potential reputational damage are ever increasing for any breach of data protection laws, and there are two tiers of penalties, which max out at £20 million or 4% of global revenue, whichever is the higher. Plus, data subjects have the right to seek extra compensation for damages. The UK GDPR defines an array of legal terms at length, and below are some of the most important ones. Personal data is any information that relates to an individual who can be directly or indirectly identified. Names and email addresses are obviously personal data. Location information, ethnicity, gender, biometric data, religious beliefs, web cookies, and political opinions can also be personal data. And synonymous data can also fall under this definition if it's relatively easy to ID somebody from it. Data processing is any action performed on data, whether automated or manual. This includes collecting, recording, organising, structuring, storing, using, erasing, so basically anything you do with personal data. A data subject is the person whose data is processed, and these could be your customers or site visitors. And a data processor is a third party that processes personal data on behalf of a data controller. This could include cloud servers or email service providers. The UK GDPR places specific legal obligations on data processors. For example, they are required to maintain records of personal data and processing activities and will have legal liability if they are responsible for a breach. A data controller is the person who decides why and how personal data will be processed. If you are an owner or employee in your organisation who handles data, this was you. If you are a controller, you are not relieved of your obligations where a processor is involved. The UK GDPR places further obligations on data controllers to ensure contracts with processors comply with the UK GDPR. Whether an organisation is a controller or processor determines its responsibilities under the GDPR. The relationship between a controller and processor is typically set out in a written contract between the parties processing personal data. Under the UK GDPR, there are 7 key principles of data processing. This includes lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. Article 5(1) of the UK GDPR requires that personal data should be processed lawfully, fairly, and in a transparent manner in relation to individuals, collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes, adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed, accurate, and where necessary, kept up to date, and kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data is processed, and then processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage using appropriate technical or organizational measures. The accountability principle ensures that the controller is responsible for and be able to demonstrate compliance with these principles. To comply with data protection legislation, you must identify at least one lawful basis for processing and sharing personal information in order to satisfy the accountability principle. The lawful basis for processing are set out in Article 6 of the UK GDPR, and this includes consent. The individual must give clear consent for you to process their personal data for a specific purpose. If there's a contract in place, the processing is necessary for a contract you have with the individual or because they have asked you to take specific steps before entering into a contract. If you have a legal obligation, i.e. the processing is necessary for you to comply with the law, or there is vital interest, the processing is necessary to protect someone's life. If the processing is necessary for you to perform a task in the public interest or for your official functions, and the task or function has a clear basis in law, or you have a legitimate interest, i.e. the processing is necessary for your legitimate interests or the legitimate interests of a third party, unless there is a good reason to protect the individual's personal data, which overrides those legitimate interests. When organizations lend or borrow, i.e. share personal data, there are expectations that some form of agreement will be in place and that the personal data will be treated appropriately. This can be seen with the inclusion of data protection clauses in contracts. However, more recently, we are seeing the use of data processing agreements. So data processing agreements, i.e. DPAs, are not optional. Any company or organization that shares personal data with third parties must have a DPA in place with these third parties. So some common data sharing scenarios include retailers sharing customer details to payment processors, marketing departments emailing customers through a hosted mail application, employers outsourcing services such as payroll or HR, companies using third-party help desks or other support functions, businesses using online office tools such as those provided by Google and Microsoft. The UK GDPR requires that all the above scenarios and all other data sharing operations are covered by a DPA, and a DPA as a minimum must include each of the parties' roles, the purpose of the data sharing, the type of data that is to be shared between the parties, the lawful basis for the sharing of this personal data, responsibilities for upholding the individual's rights on both sides, rules for formatting, retention, and security, and the standards set, such as how the principles of the GDPR will be upheld. Many online services and applications provide a DPA as part of their terms and conditions. However, where this is not a case, a separate DPA will be required. A DPA between two parties sharing data is mandatory under the UK and EU GDPRs, and fines can and have been levied where DPAs are not in place. A DPA is a crucial tool in setting the expectations of and the rules for each party, which clarifies rules, responsibilities, and liabilities, helps to ensure compliance by both parties, builds trust between the parties sharing the data, which in turn gives customers, employees, and other data subjects confidence that their data is being treated lawfully and fairly. So the golden rule is, if personal data is being passed between two organizations a DPA is required. There's one exception to this, and that is if there are 2 or more companies that are defined by the GDPR as being joint controllers of a particular set of personal data. They do not need a contract between them. However, they must still have transparent arrangements covering the agreed roles and responsibilities for complying with the UK GDPR, and the main elements of the arrangement should be made available to individuals, for example, in a privacy notice. So that is all from me, and I'm going to pass over now to Chris Kelly, who is going to speak more on the practical elements of complying with each of the legislation.
Brilliant, Catherine. Thanks very much for that. Great overview of the law and where we've got to, where we are now. So in terms of brief, for anybody that doesn't know us or hasn't worked with us, we're essentially a team of experienced barristers who specialise in helping organisations and businesses manage their compliance obligations. And one of obviously compliance obligations that falls on businesses are GDPR and data protection. And we do this through advice, training, certification, those sort of things. And in terms of who we've worked with, you can see there a lot of our client base is barristers, both in UK, some down south as well. In terms of the type of businesses that we work with, these are broad remits across legal, solicitors, barristers chambers, tech industry, and construction. And again, they're both here and in Northern Ireland. So moving on, thank you, John. So look, it's going to give you a brief overview of what we talked about. I think in terms of key definitions and principles of GDPR, Catherine has covered an awful lot of that in terms of the legal side of things, but what I can talk about is a practical nature and why it matters, and then we'll finish off as to like why does it matter for your business, and also why does it matter for you as an employee, because a lot of people don't know the burden and potential ramifications if you as an employee get GDPR wrong. People just see it as well, that that's my employer's issue, which isn't the case. And then finally we'll take a look at what things should we have in place really. So as Mark said at the very start, look, when GDPR came into place, there was a big panic. Everybody thought, look, we need to do something. They tried to get a few things in place, might have done a bit of training, so that was done in 2018. And it hasn't really been touched in the ensuing 3-4 years, but now we're 4.5 years. We are certainly seeing a number of businesses come back and saying, look, there's definitely issues here that we haven't got rectified, and we need to constantly look at it. So I think a lot of it is through work and tenders that businesses are going for, and that's both public and private sector, that they're starting to be asked questions about their data security. What security do they have in place, both for hard copy and electronic documents? Do they have a list of the legally required policies? And what training has been done? Is there any cybersecurity training done? It's a whole number of things. And if you can't affirmatively state that, yeah, we've done it, you're not going to get the tender. And we've seen a number of businesses be turned away or come to us at the last minute and say, look, we need to have these things in place, and that's something that we can do. We can get it done quickly. So in terms of data protection, that's been covered off, brought in May 2018. It really just seeks to empower individuals to take control of their personal data and support businesses to ensure that they have a lawful basis for processing the personal data. So the ICO, I'm sure a lot of you will know that is the Information Commissioner's Office, who's the regulator for data protection in the UK. So the ICO is responsible for investigating organisations that have had a reported breach, or perhaps dealing with a complaint that has been made by a member of the public against that organisation. It's essentially a regulatory body that you have to answer to if something goes wrong. So your business or businesses that are controlling or processing data will have to register with the ICO. And if you don't register with them, they can levy a fine of between £400 and £4,000. It'll be determined on how long of a period did you and the business go without actually registering, but we've seen these fines handed down for people that haven't, and businesses that haven't been registered. I'd like to touch on personal data. So personal data can be anything from your name, your date of birth, email address, and home address, right up to your financial information. So bank details, cards, all those sort of things, which a lot of people seem to think that is going into the sensitive personal data, but albeit it is sensitive to you, it's really commercial. And that's why it doesn't fall into the remit of sensitive personal data. So in terms of sensitive personal data, that's also known as special category data. And this is deemed to be much more sensitive than personal data. So it needs further protection. These things are your race, ethnicity, sexual orientation, medical records, political views, biometric data, those sort of things. When we've been speaking to people in the construction industry, they would say, no, look, we wouldn't deal with any special category data, but for our employees and their medical records. So when we actually delve into it, we could see in terms of the medical records, there's obviously injury on site forms that are completed. These are normally done hard copy, and if they're done hard copy, they're then they're duplicated and put into network, and they're saved as soft copies. And then there's a question as to how long the hard copies are kept for, how they're disposed of, how long the actual pardon me, how long the soft copies are kept for, they're kept indefinitely, and all these things, they really all feed back to GDPR. And if you don't have a lawful basis to process, then you're going to have to look at how do we dispose of it, or do we need to change some of our policies. And another one in terms of sensitive personal data that a number of people in the construction industry wouldn't think about is CCTV images or dash cam footages for vehicles. So obviously they're capturing footage on a daily basis, and they're a number of individuals, you know, their facial recognition, so that constitute biometric data. Also, it can give an indication as to somebody's race and ethnicity. So that's something that needs to be considered. If you are, you know, if you're a controller of CCTV or any media footage, then this will have to be indicated on your privacy notice, as well as your data retention and disposal policy, but we'll touch on those and go forward. And Kevin's covered off the controller and processors and exactly what they are, and give you a bit of insight as to like what would be a processor and controller relationship. And then in terms of lawful basis, there's 6 lawful bases, and a lot of you will obviously have heard of consent. You know, when you're on a website, you see the box at the bottom saying after you buy, you know, t-shirt, I click on it and you're happy to receive marketing emails. And then after you get 20, you're saying, look, no, I want to unsubscribe. So obviously with the unsubscribe function, it adds a layer of difficulty for a business, because if somebody then removes consent and you keep emailing them, there could be fines for the individual employee who does the email of up to £500,000, and also fines levied on the business as well. So what we always try to say to businesses, look, if you can rely on one of the other 5 grounds, 5 lawful bases, do it. So in terms of legitimate interests, so that really is, could your business keep going if it didn't process the information? So this lawful basis that we see that it's used to process the vast majority of information. So for employee data, it's within your legitimate interest to process their data. Or another one would be legal obligation for suppliers and contractors, because you've entered into a process their information to actually provide goods and services to them. So just moving on to the next slide, it was in terms of the principles. So I'll just run through these quickly. In terms of the lawfulness, fairness, and transparency, this is really outlined in your privacy notice. So the privacy notice should have 10 pieces of information. These things range from very simply, who's the data controller, what type of information you process, where's the source of the data coming from, right up to who you're sharing the data with. Is there any transfers of data outside of the UK, outside of the EU? And look, if you have a data breach, the ACO are going to look at the business's privacy notice. If it's not up to scratch, then they're going to delve deeper. So it's an easy win for businesses to have that in place and have that clearly on display. It's normally on the bottom of your website, the very, very bottom of the page. Click the privacy notice and it'll come up. And if it's not easily accessible, again, that's something that's a red flag to the ACO straight away. Moving on, I'll touch on accuracy. So, it's exactly what it says on the tin in terms of any data that you hold has to be accurate and has to be up to date. And the onus is actually on the employer to make sure that employee information is up to date. It's not on the actual employee, which a lot of businesses aren't aware of. Storage limitation is a big one. So it's essentially how long you are processing information for, and the ICO and statute doesn't dictate how long you keep information, but you have to, as a business, look at all the categories of information that you hold and determine what is relevant retention period. So for employees, this will obviously be their period of employment and maybe a few years after. But for job applicants, we are seeing a lot of people hold that information. So somebody sends you a CV by email. Is it always kept in your email? Is it stored on a SharePoint? If it's stored on a SharePoint, is it then deleted from emails? If it is this just what you're doing? Is it what all of the other HR managers are doing? There's a number of questions there, and there's been a number of fines. Recently, there was Cathay Pacific were fined £500,000 for essentially the security principle, which is number 6, but also the storage principle, because they held the information for much longer than they had a reasonable basis, essentially, to hold it. We were working with a local insurance firm recently where they received a subject access request from an individual. So the subject access request came in and asked for all the personal data held on them. They had been an employee of that business for, I think it was 37 years. So it was a lot of data, a lot of information, and some in hard copy, some in soft copy. And because the insurance company didn't have proper retention periods, it didn't even have a data retention disposal policy, which is legally required to have, they had to assign 2 individuals to start looking through records on site, off site, and troll through computer records. And it took them over a month for 2 employees to actually go through all of that information to then respond to subject access requests. So you can see the link between how long you store data for and responding to subject access requests. In terms of the security principle, number 6, so this is, it's always clear that it's a principle that the ICO has carried out the most investigations on. So on this principle, you'll need to put in appropriate security measures for your business. So we're always asked, like, what is the level of security that is required? So it doesn't set, there's no set guidelines as to what equates to good security, but the law does state that you should have security appropriate to the nature of the information in question and also the harm that may be caused as a result of misuse or accidental loss or destruction of that data. And as Catherine mentioned about the accountability principle, this is an overarching principle. So essentially, in terms of GDPR, you could be doing the first 6 principles brilliant, magnificent. Sorry. However, if you can't evidence your compliance with the data protection principles, it's useless. You have to have written evidence that you comply. And so as part of this, you should have policies that are legally required. So there are 5 policies that are required. So it's your GDPR data protection policy, your privacy notice or your privacy policy, your data retention and disposal policy, your data process register, and also your data security policy. And just moving on to the next one. Thank you, John. So look, why does it matter to your firm? So straight away, there'd be massive professional reputation damage if you have a breach. There always is, you know, if you type in the likes of British Airways or EasyJet breach into Google, it just comes up straight away. And now with the world that we live in, look, it's reported in newspapers, online articles, social media, broadcasting TV and radio. It's out there and it's immediate and it's everywhere. Your business is going to become well known throughout the industry, and I suppose beyond. You know, given that it's Northern Ireland again, for its lack of security. So the things that you have to ask yourself is, how much value do your clients place on your reputation? Will they continue to trust you with their personal information? Suppliers, will they decide to move elsewhere? That, you know, then will they still work with yourselves? And as it said before, just touched on, in terms of the private and public sectors, organizations are seeking assurances of data protection and compliance, and you will increasingly be asked to enter into data sharing agreements or addendums or amendments to contracts, and you're within that you can be asked to provide evidence of GDPR compliance, and this has to be done annually. So you can see there the large fines of 4% of your turnover, whichever is higher. And I was looking at the figures actually this morning before coming on, and for the last financial year, the ICO fines moved up by 1,580%. So that's, you know, those numbers, and it's a steady trend that's going up and up and up. And this constituted £42 million of fines in the last financial year. So, you know, obviously here is the large, really, you know, multi-million-pound fines, but it's not just that. It's not just these fines. That we'll talk about a few more that they're, you know, they're big enough numbers. They're £10,000 to £100,000, but it makes you think from a business perspective. Could your business survive if you got one of these fines? And it's obviously for up to 4% of turnover, so it's, you know, they're not tax deductible or anything. Another one that we're seeing more and more prevalent is damage claims from clients. So it's civil claims that are coming in against, you know, a number of businesses. Even police service 2 years ago was it started a civil claim against them. It was an individual who had been subject to domestic abuse, and the Greater Manchester Police, who were the defendant in the case, they had used the individual's information for training purposes. However, they didn't anonymize all the detail, and you could clearly, you know, from the training, you could clearly identify the individual and her medical records as well from it. And she won her case, and it was for £75,000. So straight away, you can see how easy you can fall down in that. Obviously, we touched on loss of current and future work, and the panel tenders, particularly for government work. We're seeing that more and more often, that they're asking specifically around GDPR and also cybersecurity. What security measures do you have in place? Do you have external IT assistance? Who's your DPO? What training have they done? A number of different things along the way. And I think the last one is that the ICO will publish your name on the website. So this is the business name and also the individual's name on their website. So again, you type it into Google and it'll come up straight away. Even if you have a data breach and the ICO will come back and say, look, you've done everything that you possibly could have, there's no further action on our part, your name will still be on the ICO website, and a good investigative journalist will find that straight away, and you just know what they're like. They'll print the story. So moving on to how does it affect you as an employee? So obviously, if you are the one that sends the wrong email or loses your laptop, whatever it is that causes a data breach, straight away it's going to damage your own professional reputation. Look, it's a small enough sector, and even given in Northern Ireland where we work, the word will get round, and it'll get round very fast, and you may find it difficult to then progress internally, and equally as difficult to find another role. It's not just an issue for here and now. We've seen it over the last number of years, it does stick with individuals. Criminal conviction, which a lot of people aren't aware of. So they didn't know that you can be prosecuted in a criminal court for breaching GDPR. These proceedings are instigated by the ICO against business owners as well as their employees. So you can face criminal prosecution if you unlawfully collect, communicate, or procure certain personal data, if you are selling personal data, perhaps if you're processing personal data without actually registering with the ICO. So that's you're getting it from both ends. You'll get up to £4,000 fine for not registering, and then also criminal proceedings. There was, I think it was about 2.5 years ago, there were two individuals who worked for a garage, and people were coming in, obviously they had, vehicle injury or vehicle accident, brought in their car, van to get fixed. The two people who worked in the garages were then passing their information on to solicitor firm, who were giving them backhanders essentially, because then the solicitor firm were trying to, I'd say, strong arm the individuals into making a claim. The two garage employees were fined. They were given suspended sentence, so it's only one step away from actually going to prison, and they were ordered to pay costs of over £1,000, have 100 hours of community service, and they had confiscation orders. So essentially, they had, from the proceeds of their crime, they had went and bought certain items, and they were confiscated up to the value of £15,000, I believe, for one individual, and £25,000 for another individual. And the last one there, just to mention, is you could be personally fined up to £500,000 if you breach the PECA rules, which are the marketing rules. So there's a whole litany of things to actually think about in terms of your marketing approach. So look, any questions, anything like that, you can reach out. So just going on to some actual real life examples. So we have a solicitor's data breach here. So it was a large firm called Tuckers in Manchester. They were subject to a ransomware attack on the 24th of August in 2020. The next day, they realized the extent of the attack, where there was over 1 million of their files were actually accessed, and I think it was 24,500 roughly court bundles were accessed, with over 1,000 of them being deployed on the dark web. So an ICO investigation followed, and they found, and look, there was a number of breaches. They were critical that they weren't using 2MFA when securely accessing remotely. They didn't have any training. They hadn't gone through any GDPR audits, and as such, that was the reason for the £98,000. Now, if they had done training and audited, or had appropriate security measures in place, the ICO, there are a good enough regulator to deal with. They would have said, well, look, that's mitigated, and we'll bring the fine, we'll bring it down. Probably it would have been below half that, because if you can demonstrate that you're taking appropriate measures, then the ICO will, as I say, they'll be good to deal with. Essentially, I don't want to say the exact numbers or anything, but yeah, I do think it would have been roughly half of that. So the next case is the Scottish HIV charity case, which is very unfortunate and for me, it's something that can very, very easily be done. So it was a HIV charity in Scotland. They said it was one of their administrators had sent an email. Instead of using the BCC function, they'd use the CC function to, it was 105 of their, I suppose, their clients. Of these individuals, they were all HIV positive. So by CCing everybody, they knew that the other 104 individuals had HIV, and therefore a disclosure of their sensitive personal data, being their medical history and their medical records. The ICO came in and had a look at what had happened. So if you have a breach, the ICO come in and ask 2 questions. Look, give us an outline of what has happened, and number 2, what training has everybody within the organisation done in respect of GDPR in the last year. So they give them an outline of, this is what happened. We used BCC instead of CC and the training. So the ICO asked for a copy of their training. The HIV charity, they were very proactive. They had spent $2,500 on the training that all employees had done. The ICO came back and said, look, it's essentially, it's not worth the paper that it is written on, and you spent $2,500 because it wasn't appropriate training. The level of the training was very, very basic. It was for people who didn't have email addresses. So they think in the likes of cleaners, something like that, they would have to do a lower level of training. For instance, somebody who deals with a lot of sensitive personal data or has access to personal data, a number of employees' personal data. So that's, it's very, very unfortunate for the HIV charity, and they were fined £10,000, which was 3.4% of their annual turnover. 10,000 doesn't sound too much, but when you link it to what their actual turnover was, it was significant enough. And now moving on to the next one. So this is Trinity Chambers, which is a barrister's chambers in England. They were returning case papers for a commercial case. It was sent to one of their clients. Well, they thought it was sent to one of their clients, but it was actually sent both by way of post and email to the wrong address. There was no sensitive personal information whatsoever in it, but the ICO still found that the appropriate safeguards were not in place, the appropriate checks weren't in place, and levied a £10,000 fine. There's a number of other fines as well. Next slide, please, John. Thank you. Which is just, it's a very, very high level. So in terms of the CCTV footage, this was outside a pub, and the bar owner, there was a fight outside the pub, and the bar owner then sent the video around in a WhatsApp group, which in itself it's horrible practice. But a bystander who was in the video got hold of it and then took umbrage with the fact that his facial image was not blurred out, and complained to the ICO, and the ICO levied a £3,000 fine. I believe that civil cases ongoing in that, and the data subject is still trying to sue for damages as well. So another one, inadequate privacy notice, didn't have the 10 elements. Straight away, it was the equivalent to DPC, which is the equivalent to the ICO down south. They fined the business €6,000. Documents left on the train, very, very easily done. Leave it on the bus, leave it in your car, and the car is broken into, £70,000 fine. One of the last ones there is the use of WhatsApp group for discussing client information. So this is a healthcare business that specialized in COVID-19 tests, and they had a group for all employees, and they started talking about different test results for individuals. This was then notified to the regulator, and the regulator got hold of all the WhatsApp messages, had a look at what the procedures were, and there's a number of things in terms of security, the retention of data, and also the required policies. They just didn't have any in place, or whatever they did, it wasn't adequate, and they were levied with a fine of €80,000. So it's very, very significant here. So finally, just checking the checklist on what you should have as a business. So number one is annual GDPR training. It's a must, and the training has to be appropriate to the level of the person and the amount of personal data that you process. There should be some sort of test and certification if you pass the test at the end. We touched on policies and the notices as well. There's 5 legally required policies and notices, and then also data sharing agreements if you're entering into, or not even entering into, but if you're passing data that you control to a data processor, then there has to be some form of data sharing agreement there. And the final one is support. So support, it can be internal or external, but somebody within the business or external support to come in and have a look at the risks that currently are in place in the business, and then taking steps to mitigate these risks. Because if you can demonstrate that you've taken appropriate steps, it'll certainly mitigate against any fines or civil claim against your business going forward. So yeah, that's my part finished. So look, thank you very much for listening, for joining. Really appreciate it. Any questions for us?
That's great, Chris. Thank you for that. And Catherine before you as well. That's very comprehensive and actually quite scary, if I'm honest. We have a couple of specific questions in from folks on the webinar. The first one is, it's a property developer building their own homes, obviously have their own website, and they have a web inquiry form on their website. Maybe for yourself, Catherine, what they're asking is if they're collating expressions of interest from home buyers and collating a list and passing that on to estate agents that they've appointed to market the properties. Are they in breach, or what should they be doing to make sure they're not in breach? So they're inviting people to express interest in passing their details on to an estate agent. What would be the steps they should be thinking of there?
I think as long as maybe they have terms and conditions or data privacy policy available to each of the individuals that they can read, just to know how their data is being shared with the selling agents, and just sort of know what the purposes of the sharing is. I think that should be sufficient.
Yeah, grand, super. Should all your corporate emails have a standard privacy notice attached to the email?
I'm happy to take this one. So in terms of that, it's the privacy notice is for the business as a whole. It's not for any certain element of the business. So in terms of emails, they don't have to have their own privacy notice. You can provide reference or a link to the business privacy notice in your emails. That's something if you feel it's necessary, you can do. But generally, it's when people come back and ask how you're processing our data, then you would send them a link to the privacy notice. And if they have any further questions, it should be detailed on the privacy notice who they should contact and the method of contacting them.
Okay, super. Thanks for that. Well, the general question then really, I suppose, asking for practical examples of how to apply it. I think you partially answered that, Chris, with the checklist. So maybe if we phrase that question, if we haven't given GDPR its place to date and we're starting fairly fresh, where would we start in our business today to become compliant? What would be the immediate actions we should be putting in place?
In terms of immediate actions, yeah, it's really reverting back to the checklist. So number one would be the training. That's what we see. Like, if it's between the training and going in and completing a review of where everything is at, do the training, because that if you have a data breach, they'll, as I said, they'll ask what training have you done and what happened. So if you can answer both of those, or if you can answer the training affirmatively and say, look, it's been done in the last 6 months, then it'll always be good in your favor. There are the legally required policies and notice this, as well as the data sharing agreements that Catherine had mentioned. So yeah, look, I feel that you would have to do both, but once you get the policies and notices and the agreements and the wording around the agreements, in place, then they would just need reviewed annually. But in terms of the training, there has to be new training done every year.
Okay, well, thanks for that. I was intrigued, I suppose, from the point of view of breaches, that you're not just open to the actual fines, but you could be pursued by individuals for compensation as well. And I suppose there's no, I was going to ask you, what does that look like? And I know it'll be variable depending on what the extent of perceived damage was,
Yeah.
but, you know, thinking of local family businesses in Northern Ireland and the types of activity construction companies are involved in, what might be a typical scenario there of somebody who feels in some way they've been damaged, perhaps, or maybe it doesn't occur so often, maybe that's not the type of breach that we see so much in our sector.
Yeah, so look, it can be that, you know, if it contains sensitive personal data, then that you're likely to be facing a higher claim against you, because there's a greater likelihood of discrimination against the individuals. So in terms of the construction industry, if you have on-site medical reports and, for instance, you set them down there, they're stored away in a locked cabinet, but then the locked cabinet it's broken into, and somebody has access to medical records that happened on site for the last 3-4 years, and then these records are, you know, they're either handed out or they're disclosed to a third party, or they're put in the dark web. Then that's, you know, that's a breach, and it falls in your business because you didn't have the appropriate security measures in place. So in terms of the level, you know, compensation, I can't categorically state if it's a certain level you're looking at this, or if it's higher level sensitive personal data, you're looking at this. But essentially, people are starting to see it as the new whopper, slipper, and trippers.
Yes.
They know that they can make a claim. It's easy enough.
I was going to say, I mean, is this an area now where we're looking at ex-employees, disgruntled employees, competitors, you know, raising, I know they're not malicious claims, because if you're in breach, you're in breach, but are people looking to aggravate the situation?
Absolutely. We see that with subject access requests as well by disgruntled and vexatious employees, that they're just doing it to try and tie their ex-employers in the ball, really.
Tie in knots. Just a question about data sharing agreements, and I think it's a very good question, because you might think you're compliant if you have the privacy statement on the website and you think you're managing your data. What are the scenarios for requiring a data sharing agreement? Who would you be agreeing that with? And maybe the previous example was a developer with an estate agent. Would that be a scenario where you have a data sharing agreement, or are there other examples where you would need those? And if they're not in place, are you in breach?
I suppose this one, Mark, will depend on who is sharing data and who they're sharing it with, and what the purposes is of that, you know, for sharing it. Is it, if you're a controller, you're the person who's collected the data, and you decide what way it's going to be processed, and you're given to somebody else to be processed, that's a data processing agreement. So it will say, look, I control the data, we control the data, you're going to need to secure it in certain ways. These are the types of data you'll be given, and this is exactly what you can do with it. In terms of data sharing, it's a data sharing agreement more when it's sort of controller to controller. So somebody else, you're just passing the person's data on for somebody else to control and decide how it gets processed. In that instance, you're going to need to have the consent, which could be built into your privacy statements. And as long as it's very clear on what you're going to be doing, who you're going to be passing to, you'll not need that data sharing agreement. It's only where you will need that consent. You will need the person whose data has been passed on. You'll need their consent to do it. And the sharing, just sort of a sharing agreement, again, sort of says, look, we're passing on to you, you're a controller as well, and they both have the same obligations to keep things secure, and you know, they can then decide how it's processed. So it's a little bit dependent on the circumstances there, and you know, for people who aren't maybe dealing with this day to day, it can be a little bit ambiguous and unclear. But look, that would be one we'd be happy to say to people, look, you know, give Catherine and I, or Chris, if it's more on the sort of compliance side, an email, and we can sort of talk through, because the circumstances will very much dictate what needs done there.
Okay, no, perfect. And just a specific example there, and would be very common in our sector, would be sending employees for training with a third party training company, and obviously you'd be sending along a list of attendees and maybe information around those attendees in terms of skills and so on. So would that be a scenario you'd recommend an agreement with the third-party training provider?
That's one again where you'll build in the consent for your employees, because it's in part of the services they're providing to you as your employees. The third party will sort of collect the data and want something sort of signed to say, look, this is what they're going to do with the personal data, and this is, you know, the service they're going to provide. But it's one where your employees will consent, possibly through their employment contract, to say, look, you know, this is what we'll be doing with your data. But it's very much a communication piece to make sure the employees are aware you're passing their data on, that they consent, you saying, yes, you know, I'll sign up for that course, give them my email address and my name.
And do we need the agreement with the provider for our own benefit to make sure that they are fit to handle that data securely? Yeah,
look, in an ideal world, and let's sort of, Chris, take this in terms of the, you know, the sort of levels we're at here, but that will, you know, the third party will be a controller as well in most instances, because they're going to be providing their own service to the employee or to your business for the benefit of your employees. So they will probably have some sort of data sharing word in their agreements. It'll depend on how, you know, sophisticated that organization are. They may not, and then it's a sort of case where it sort of depends on the levels of, you know, what's been done here. What is the risk? You know, there's, as Chris has sort of touched on, there are certain areas where there's huge risk, and you'll always be advised and have everything tight in terms of the agreements. But it may be one where they just don't, and there's privacy agreements, and they will, you know, you can maybe just take a view in that perspective rather than getting bogged down in the sort of paperwork. But I'll let Chris sort of touch on that sort of level.
Yeah, I would agree. Generally, you know, I'm sure everybody would know that the annexes or schedules to contracts generally have a data protection addendum or agreement in place. So if if you're dealing with a large training provider that provide training to over 1 million individuals, generally they're going to have something in place already. You have to look at what's the risk to the business of us actually going in and changing that schedule or that data protection addendum. Are they going to agree to it? Like, probably not. So it's generally, if there's something in place already, then you should be okay. But if there's nothing in place, you're well within your rights, absolutely, to say, look, here's our standardized data protection agreement. Can you put this in the contract or sign it as a standalone agreement, and you can have it running indefinitely. There doesn't have to be an end date, doesn't have to be reviewed or anything like that. It's just you hereby adhere to the appropriate security measures as outlined in GDPR, something along those lines.
Okay, that's great, Chris. And that is all the questions that we got through, which is very timely because we're nearly at the full hour. I've learned a lot there. I've taken some actions away. I'm sure everybody on the call has taken some actions away. One of those actions will be check your emails, because we'll be sharing the slides and the link to the YouTube upload. And you have in front of you there the contact details for Glenn, Catherine, and Chris. Thank you, the three of you. That was a fantastic, comprehensive presentation this morning. Really enjoyed that. We look forward to many more Mills Selig webinars in the coming weeks and months. But thank you, everybody, for joining this morning. Hope you find it useful, and see you again. Thanks very much.
Thanks very much.
Thanks.